You're live.
Welcome to House Education, April 16th. The committee this morning is hearing from a number of sponsors of amendments to H 955. We're going to begin with Representative Olson of Starksboro, who has two amendments, and going to hear him present those amendments. We'll later do a quick walkthrough with Legislative Counsel, a little testimony, and then we will straw poll them thereafter. Representative Olson, I do not know, do you have an order you would like to go in? You have two amendments.
Yeah, our intent was to have them proceed sequentially in the order that they appear on the action calendar, so I can do the same here.
Okay, just tell us kind of by description which one's first.
The description is the quote vote amendment would be first, followed by the quote administrative hearing.
Okay, great. Thank you.
And the vote amendment is page 1943 of the today's action calendar. And the administrative hearing is the following page.
Floor is yours.
Okay, great. Well, thanks very much for having us in here. Representative Iacovone and myself, as well as the co-sponsors, wanted to offer these amendments in order to, give folks meaningful votes before their school might be closed. We think that's pretty important for these communities, for these parents, for these students, and within the larger context of what we're trying to do with education transformation. I think it would be a real plus, not to make sure that people have a say before their school is closed. And there are two ways to do that in our mind. And the first has to do in the First Amendment that would be accomplished by a vote in the electorate where the town where the school is located. I had to change that wording. There are, as you know, there are a whole bunch of different sort of parameters of what a school district is. And so we tried to encompass both situations where there were multi-towns with a single district, as well as to try to exclude municipalities where they had it was a single municipality district. Like I remember when we came in earlier, a question, what do you do about Burlington? What do you do about Lincoln? That kind of thing. Didn't feel that was within the scope of what's necessary here because you have that direct relationship. So that's the point. There would be a vote there. That's subsection A. Subsection B.
Just pause for a quick second. I think what I heard and what I'm reading are somewhat different. I thought I heard you say the town where the school is located, but subsection A says a vote of the electorate of the towns served by the school.
Yeah, so we're trying to, again, take into consideration the variety of ways in which school districts are operated. So maybe take some examples. The school district in my area is a merged district. It's a supervisory district kind of thing. It's a unified school district. So the notion there would be if the board wanted to close one of the schools, for example, an elementary school there, they would have to have a vote in the town where the school is located. But we acknowledge that there are some school districts that are configured differently. There might be a multi-town district that has a single school, elementary school, sometimes in much smaller towns. So in that circumstance, it seemed right that all the residents of that district would get a vote if their school, because they all feed into that school, were to be closed in a larger structure.
So just in the terms of examples from your area, in addition to having a single town elementary schools, you also have a unified union high school. It's serving 5 towns. So in order, if your district were to merge with another district and say we only need one high school or one high school middle school, in order to close one of those, in order to close the one in your district, it would require a vote of everybody in the 5 towns that it serves. Is that correct?
Are you thinking of a merged district after that, or what?
I would say, it doesn't matter. I was just saying that if the school board that oversees the high school in your district
Right.
decides to close it, I'm assuming this would say that the voters in all of the towns that feed into that high school would be voting on whether it can be closed or not. I just want to make sure I'm right on understanding that.
Yeah, I think that's correct. Whether that is the perfect way to do it, I'd certainly be open to discussion. I mean, it's tough when you're trying to put together an amendment and you haven't had the opportunity to come before the committee who really knows a lot about that. But that's what I would think right now.
Representative Long?
As a quick follow-up, so some of those, using this example, some of those those union school districts have commingled ballots and vote in one lump, and
Right.
some I think don't.
Oh, is that
So
right?
it would be required to follow whatever the current rules are. I guess I'm just trying to figure out what your plan.
The one, yes, again, there's so many different configurations in terms of governance. I think in our situation
Yeah.
with Unified Union District, it's always commingled.
And yeah, okay, so what I'm trying to say is that when you commingle them, that's a different vote than if you had, all towns separately having to vote to.
Right, but I think in the example posited by the chair with the high school, I think that would be a commingled vote under this example. But if it was, say, an elementary school in that district, it would be the town, the voters of the town where that school is located.
Who was next?
And I'll just say that I worked with Beth to try to cover as many permutations of this as I could. I thought it was important, when you have a single municipality district, I think that's horse of a different color. And it's not, this isn't necessary, you got a direct link to the voters.
And it probably isn't covered by this, but I have to ask a question, because where I live, we have a lot of tuitioning. And so a town that, because I'm thinking that's not really the town that served or the family that served, because I'm from Concord. We don't have a high school anymore. We tuition out to all the other high schools in the area. If one of them decided to close, does Concord get a vote in that because we tuition kids there? Are we?
So maybe some of these
But I'm
questions-
thinking no.
I'm thinking maybe some of these questions are best for
Yep.
Ledge Council. I think the term union school district shall
Yeah.
be
Yeah.
something that.
I think-
And the electorate of that. So, I'd defer to Beth on that answer. My sense it would be no, but because it talks about electorate. But Beth would be much better able to talk about it.
Representative Harple?
No, I was just gonna offer examples, but I feel like there's enough examples on the table. I don't need to muddy the water.
Okay. Okay, why don't you continue on?
Yeah, so that was subsection A. Subsection B simply gives some parameters about how information, voters need to be well informed about this. It's a critical decision. And so the idea would be that the board would post a report giving their thoughts, their rationale, their information, why they thought this was a good idea. There's a bunch of different factors that sort of outlined in subsection B. And then, just some sort of opportunity, whether it's by hearing or some other means for residents, affected residents to give their perspective as well. So that's the First Amendment. Let's go to the Second Amendment if you
No,
want.
no, let's finish up with this. We'll do one at a time so we can stay focused. Okay, currently, for example, your district, does it require a town vote to close a school?
Yes, per our articles of agreement as they exist now, whether that would change under the merger study committee kind of thing, that's an open question.
But that was decided locally to have that as a feature of your articles of agreement.
Oh, yes. The merger, Act 46 merger would not have happened without those articles. It was a very close vote in a couple
But
of.
that was a decision that your merger study committee came up with when they did the articles of agreement. It was not something that was sort of mandated by the state.
And it was something that the individual towns voted on.
Right.
Which is part of the reason why I'm a little concerned about, what's going to happen in the future with study committees, possible mergers, is that aspect of existing structure going to continue? It's just a valid concern.
Committee, just, if there are any questions, do you want to move on to the next amendment, or would you like to have legislative council sit in for a quick second on this one before we move to the next? Why don't we
Just
why don't-
second,
do the second one
because it's
first?
sort of related to the
Okay,
first. isn't
great,
it?
let's do that.
The second is related to the first. It tries to get at the same sort of goal, which is that before a school is closed, there has to be some sort of accountable way for to the decision. Make sure it's not an arbitrary one. It sort of gets into the sense of what's due process about. It has to be specific to the individual decision. It has to be based on fact, and folks get to participate in that kind of hearing. So the just running through.
Are you saying that doesn't happen?
I'll explain in a minute what we're asking for.
Okay.
Under current law, a school board has the authority, absent articles of agreement, the school board has the authority basically to close a school for any reason or no reason at all. So what this would do would be to say, yeah, you can close a school. I'm not saying that all schools have to remain open. We're really trying to sort the wheat from the chaff here. But before you close a school, you go through a process, a hearing, notice an opportunity to be heard. There are established statutory standards for that. And then if they conclude it's in the best interest of students in the town served by the school, they can close the school. The subsection B talks about some of the factors that should, I think, be considered when you decide to close a school. I don't think there's anything unusual in there. It's talking about educational value, financial viability, capital costs, transportation times, those staffing issues, those kinds of things. Those would be elements that would be part of the administrative hearing. So that's that subsection B. Subsection C simply says, it's good to specify, well, what do you do from that hearing? And there are a bunch of different options under the law. So we thought it would be helpful to clarify that this would be simply simple, on the record review in the next step in a court proceeding. Any decision of a governmental body, state or local, in my understanding, probably is going to go through, you can always appeal it. Anyone can appeal anything. And it probably will be pursuant to this Rule 75 that I identified there. But I thought it would be helpful to say you don't have another full-blown hearing, evidence and all that. It's on the record. The record would be developed by the board. And then if you can appeal it, the judge would just take a look at the documents and the record and make their own decision.
So I'll be very honest. Never heard of Rule 75 of the Vermont Rules of Civil Procedure.
Well, you have to be a government lawyer for a long time to be.
There's no hearing. A judge just reviews records and then makes a
I
decision.
think my understanding, it's on the record, so you don't bring in witnesses and have them testify, stuff like that. The record is compiled by the board below. Then they got rules for that. There's rules on how that happens when you go through a Chapter 25 hearing. But the court it specifically doesn't have to hear a whole bunch of witnesses. They might have a hearing, Mr. Chair, with the attorney saying, from the records, this is why we thought this was a good decision. This is the appellants, I thought they didn't give full consideration to that. So there'd be that type of hearing, but not the evidentiary hearing that takes a lot of time and complexity.
Representative Brady?
curious how we think about economic viability in a statewide education fund. Like, how does that, the economics of each system are not contained within a single district. We're all playing in a statewide education fund. So
Sure.
how would that be measured?
Measured, I think it probably depends on the specific case, but there is identify that kind of a factor that would go in. You'd have to think about economic viability. The Ed Fund isn't specifically mentioned, but certainly I would think the board, could say, geez, compared to the educational value for the students, it's just too darn small. We can't do what we need to do. Plus, it's going to cost a bunch of money. And that might be the basis for a decision that, yeah, we should go ahead with that closure.
Using weights currently, like, I guess I'm just trying to figure out how you would make such a determination. And there's so many factors and weights that go into what, what a district's tax rates are or what they're.
Right. Yes. And I think the board would probably be best situated to talk about, what the financial impacts would be depending on the district, depending on the local school. I really trying to get everything out there, pros and cons, include the pros, it's not cutting it educationally, costs too much, that would be a persuasive case.
Any other questions? Representative Brown?
You may have already said this, but how are these two instances of amendment meant to work together?
Okay, yeah, I should have started with that. So they are ordered, there's an order, and the amendment relating to a vote is first on the action calendar. If that is approved, there would be no need for the second amendment. And
Oh, okay.
our plan would be to withdraw it. If the vote amendment is not approved, then we would proceed to the second amendment.
Thank you very much.
Okay, thank you. Thanks very much for your time.
I want to be cognizant of our witnesses' time as well. Would you mind joining us, Legislative Council? It may be a quick visit to the chair. If we go back to the first amendment, I think maybe we just need a little definition here before closing a school that operates grades pre-K through 12 or any subset. A union school district shall obtain the affirmative vote of the electorate of the town served by the school.
It's 1.2 or 1.3?
This is
Oh, First Amendment.
1.2.
Two. Got it. Okay.
Is a single town that operates a single school, a union school district.
St. James, Office of Legislative Council, no.
Okay. All right, so if a school board of a single town school wanted to close their school, they could do that without a vote of the electorate.
Depends on what their articles of agreement or charter say.
Okay. Well,
And just to add on to that, in 955 with the creation of new districts, we kind of left it open for them to write their own articles of agreement, correct?
correct.
So if this were important to his region, these things could be included naturally in their articles of agreement.
Yes.
Okay.
Other questions? Thank you very much.
We need to two also or not?
Oh, yeah, I'm sorry, were there questions on the second one? I think in terms of how Rule 75 works, I don't know if anybody has a question for legislative council. I will just say that that's going to be the focus of our testimony at 9:30. Get a better understanding of that, sort of what it means.
I can hold my question till 9:30.
All right. And I think that's sort of these are largely the same other than that part of it. So if you all want to hold your questions for the next witness, that would be fine as well. But are there any further questions for legislative counsel?
Thank you.
All right, let us welcome via Zoom Judge Thomas Zone, Chief Superior Judge in Vermont. Thank you for joining us. To the extent you can enlighten us as to Rule 75 of Vermont Civil Procedure and sort of what might be the impact of adding something like this in a situation like this, that'd be very helpful.
So good morning. Thank you for having me, Tom Zone, Chief Superior Judge. I would first note that the bill sets forth a policy determination by the legislature. And so when I make my comments, they are not intended and should not be construed to be weighing in on any legislative policy decisions. Rather, my comments are intended to note the practical impact of the policy decisions as expressed in the proposed bill, if this bill were to be enacted. Additionally, I am not in a position to provide advisory legal opinions or opine as to how a court may interpret statutes. But what I can do and will do is talk, Chair Conlon, you had, in your question, you said you were not familiar with Rule 75. And so if it's okay with the committee, what I will do is talk about really two rules of civil procedure that play into appeals of governmental or municipality matters. And so the first of those two rules that the Vermont Rules of Civil Procedure have is a rule called Rule 74. Rule 74 applies to quasi-judicial determinations made by either the executive branch or municipalities when a party is entitled by statute. And hold that thought when we get to Rule 75. This says when it's entitled by statute to seek review or appeal a decision. And it defines the process for the appeal. It talks about a notice of appeal, whether there's a stay, what is the record on appeal, what is the process for a trial on appeal, and it has rules of procedure. And because it is set by statute, Rule 74 appeals often have a standard that defines the scope of their review or the appeal. One example would be, for instance, in Title 28, Section 724, where there are furlough appeals in the Department of Corrections. And under subsection C2, it says, an appeal filed pursuant to this subsection shall be limited to determine whether the decision to interrupt or revoke an offender's community supervision furlough status was an abuse of discretion. And so it specifically tells the court, here is what your review is, and it lets the parties to the case know, here is what the scope of the court's review is. Now, Rule 75 is different. Rule 75 exists to review the action or the failure to act by the executive branch or municipalities, but it's only applied where there's no right of review or appeal under Rule 74 or environmental court rules, and if such review is not otherwise available by law. And the second prong has been interpreted to limit Rule 75 appeals to what are known as extraordinary writs. And an extraordinary writ has traditionally included such things as a writ of mandamus, a writ of certiorari, a writ of prohibition, writ of habeas corpus, a writ of quo warranto, and a writ of cera facies. These writs are processes that come from the common law and chancery courts dating back in Vermont to at least 1824. Although they have a complicated history and jurisprudence, they're effectively procedural safeguards and offer equitable relief. The two most cited writs are one, mandamus review, and what this does, it looks to compel performance of duties. And the second one is what's called certiorari, which is review of a decision, and it's usually done for process or sufficiency of evidence. And so by its nature, Rule 75 appeals are limited. They rarely involve review of substantive decisions. And examples of Rule 75 that you may have experienced are certiorari review of inmate discipline cases or mandamus to compel a town to plow a road. And so those are the two rules that we generally see on appeals, again, from executive or municipal decisions. And if you look at it like this, Rule 75 is generally used to fill the gap when nothing else is provided. And so that's the background to the two different rules that we generally see. And so when you look at Rule 75 being included in this amendment, it's somewhat confusing because as equitable relief, it usually only applies when the statute doesn't provide for relief. And that's not to say that Rule 75 would not necessarily work, but it's, as I pointed out, it's not consistent to say that Rule 75 is the mechanism, because Rule 75 is usually the mechanism you use when there is no mechanism otherwise stated. Think of it like this. It fills the gap when the legislature has not acted to put something in. And there are several statutes, I would note, that do say Rule 75 appeals, but that is generally not the way it is done. And so by including it, the question for the courts, if this bill were to pass and there were an appeal filed, is what type of review is being sought? As judges, we need to understand, what is this statute? What do you want us to do? And this bill does not tell us that as far as the type of review. For example, if the intention of the legislature is that the review would be in the nature of certiorari to review, it's not fully clear that this new proposed section 564 would create the type of proceeding before the board, evidence, deliberations, decision-making, that would result in a determination that would qualify as the type of quasi-judicial decision over which a court could properly exercise that extraordinary writ of certiorari review. And apart from the standards from the writs, that certiorari review, for instance, it says it's a record review in this bill, but it doesn't provide any substantive guidance for the court to affirm, reverse, or modify the decision as provided by law. And that raises the prospects, I think, if not the likelihood, that appellants may expect a court to substitute its judgment for that of the board, when in fact the court's jurisdiction and the court's authority is much more limited. The bill also sets forth that there can be multiple appeals. It's not a single appeal. It says that it gives all the residents of the district the right to file appeals in as many as two separate forums. One would be the Washington Superior Court in the Civil Division, and the second would be the home court of the district. On its face, these appeal rights would likely give rise to numerous individual lawsuits related to any particular school closure decision, and it could even be in two counties. I'm not sure if there's any school districts that have three counties, but I do know of some that I think that are in two. And so you have the potential for two different counties. It also has the potential for dozens, hundreds, or potentially even thousands of residents seeking to file an appeal from a closure decision. And so a multiplicity of suits, which could raise a myriad of disparate issues, and that could challenge the courts with the dockets, raise the prospect of conflicting decisions from different courts and judges, and likely would lead to substantial delays, or courts have to sort through the initial procedural issues if we have, again, dozens, hundreds, or thousands of people appealing. It also raises issues about how we would consolidate those suits. Where would venue go to? Because the legislature is very clear, if you adopted this bill, that it's the discretion of the appellant that controls. And so the courts would be having to determine where are we going to send this, and there's no clear guidance. So we would have a number of procedural matters to address in determining where we're going to consolidate cases and how we would go forward. Additionally, the statute says that there's a right to appeal on the record, but we don't know what the record is before the board or the court. There's no guidance to tell us what the record is. And there's also the issue of what's called standing. Parties generally have a right to appeal an action because it's caused them a particularized injury. And even though a statute may say all the residents can apply, there is case law that talks about the fact that there still has to be some type of particularized injury. And so the issue of standing would be one which would certainly need to be addressed for each individual who brings an appeal, if that were to happen. And that happens in many ways right now in the environmental division. When individuals are seeking party status, the court has to make those types of determinations. But that is another issue that would be expected if this bill were to pass as proposed. And so those are my comments. Happy to answer any questions if that would be helpful.
You had a comment said that Rule 75 is there for when general use to fill the gap when nothing else is provided. So if not this route, then what route would be is provided under law right now?
Right now, if there were to be no specific, if there is no statute that says here is the appeal mechanism, Rule 75 would be the mechanism that an individual would attempt to utilize.
But if there was no, if there's nothing in this, if this amendment did not go through and there's nothing mentioning Rule 75, then what is the path forward?
If this amendment did not go through, the existing mechanism, because there is no statute that says you appeal under Rule 74, the existing mechanism would be Rule 75. That would be the process that would be followed. But the difference is by placing Rule 75 into a statute, it causes some confusion because when a court looks at a statute, that section and other sections, the court has to discern what was the intent of the legislature. Why did the legislature put in Rule 75 when Rule 75 is used when we don't have something in? Did the legislature really mean Rule 74? And what is our scope of review? So it does give rise to questions by putting it in.
Okay, so I just want to be clear. Rule set whether if this is not if this amendment does not pass and Rule 75 is not specifically called out, it still applies if there's no other means of appeal.
Rule 75, correct, would still apply, but I want to be very clear. I am not saying that Rule 75 is the mechanism, and if someone files an appeal from a school closure, here's how it's going to work. What I am saying is Rule 75 is an existing rule of civil procedure that if the legislature does not set forth a mechanism for appeal, that an individual, a resident, an aggrieved party can seek to utilize. How that comes out, I cannot opine on, but that is the mechanism that individuals would generally seek to utilize, correct?
Okay. I guess does the other sort of pathway, which is just a regular old lawsuit, still have, is that a process that exists as well?
Individuals have a right to file lawsuits if they believe there is a factual and legal basis. I cannot opine as to whether there would be any legal validity to a suit that a citizen could bring on this type of case. Citizens certainly can try to utilize common law and other statutes to bring lawsuits if they believe that there is something that needs to be addressed.
Okay. Committee, any other questions? Here, online? Yeah.
If I could just explain a little bit in light of the judge's comments.
Sure. Why don't you have a seat up front then?
So here's a perfect example where if you try to explain too much, it doesn't always work well. My intent in offering that subsection C was this is just a simplified type of procedure for appeal. And I agree with the judge that if we'd said nothing at all, it would be under Rule 75. It was an effort to try to make the appeal proceeding simpler, but obviously it gave rise to other questions. I'm looking over at my co-sponsor and my joint sponsor here, but I would, when this gets on the action calendar, I think I'm going to propose to just drop, that subsection C because it seems to raise more questions than what I was trying to avoid. Rule 74 is solid. It's a good process, and that's an option, I suppose. But it is more involved. I think it takes more court time. It takes more litigant time, in my experience. So we'll be we'll be making, I guess on the floor, some adjustment to that subsection C, so it doesn't result in the type of confusion that the judge was suggesting.
Okay, we may need to see that before the floor, since it'll be a change into the amendment.
That's fine. What I'm saying is that you have this subsection C, and I am going, it's on the counter, right? So you can only to drop. I'm not sure. Maybe I need to talk to the clerk or something about how to drop that subsection C. But I'll explore that with him, and I can share that with you.
Okay, thank you very much. All right, I'm just trying to keep aware of the time, but we actually have legislative council. I know you have different conflicts timing wise. When do you need to leave the committee room to 10:15? All right. This is just a question of straw polling after we hear all amendments, or do we want to straw poll these two first? We have Representative McCann still to present her amendment. Does the committee have an?
I think we should hear them all and then straw poll.
Well, that may be good for,
Yeah.
As I say, I would take them as they cut, yeah, they're very different, so I would straw poll what we just discussed.
so it's fresh in our minds.
Or yes, money on, and yeah, and I think we have to straw poll what's in front of us, so if changes
Okay.
come on the floor,
Right.
we
Yeah.
might have to recess back.
Right. Meet in the well and.
Straw poll hypotheticals.
Okay, all right, discussion?
As a person who is in one of, and represents many of the districts that these kinds of closures might happen to, I'm in full support sort of this, but I also feel like we are closer than we've ever been to getting something palatable across the finish line, and I'm really worried about the idea that this is gonna muddy the waters when it could be worked out in the articles of agreements from town to town, so I'm really torn on this.
I'll just, go ahead, Beth.
I was just gonna do the same thing as we had a lot of discussion as we were putting this bill together about what to do about articles of agreement. And we made the decision to leave it totally in the hands of those who are doing this. So I'm of a mind to stick with that decision and leave it to them.
Yeah, I would echo that. I think we have in 955 bent over backwards to make it a local process with local decision-making, right up to a vote of the electorate in the districts. And it sort of seems that mandating something in light of the philosophy of locals making the decision, locals voting on it in the end, is counterintuitive to what we've put forth here. So I'm inclined to, not to support the amendment.
But yeah, the consolidation of districts is different than the consolidation of schools. What we've enabled, or what hopefully this legislation, if it passes, will enable communities to do, is to make their own decisions about which districts that they want to be aligned with, but that doesn't mean that they're necessarily saying they want those districts to then turn around and shut them down. And without this legislation, that continues to be a risk.
Yeah, so I would just say, it's really all about the articles of agreement. And what we have here is a local process for developing local articles of agreement to be voted on by the people of the district or the districts that are merging. It's a pretty tough road because all the districts would have to vote in favor of the articles of agreement for anything to happen. So to me, it's a very locally controlled process with really ultimately the voters being in charge of what they want in their articles of agreement and what they don't want in their articles of agreement. Yep.
So I will just say I am, yes, unfortunately, very familiar with school closures. They're happening quite often around me, and the articles of agreement have been used throughout the process, and the electorate in my region has spoken against closure and then for closure in some instances in the same community over time in a process. And I've also sat through multiple community meetings by request of locals to come and listen to the engagement with community. And I felt reassured, if not sad, about some of the closures that have had to happen. And never felt it was done in my region in a crisis beyond the fact that enrollment declines are a crisis. They are, but the engagement in the communities based on current law and the ability to have, you know, a thorough conversation and over many, many months has been super important. And I feel pretty good about the fact that we have allowed that to continue in 955. And I can't see in any part of 955 that would stop what I've been witnessing from in my region of the school closure. So I don't see a need for either of these. I think that exists already.
I guess the information that I wish that I had, and maybe someone knows better than I can predict this, is like, if we did pass this amendment, would it make our old bill less likely to pass if this was attached to it?
I think that's a major political question that would require surveying the body of the House. But I would share your concern about the amount of work we put in on a plan that we feel very good about moving forward with it.
Just feel like I need to think about this. I am not ready. I don't know how I'm going to vote. This is coming up in 10 seconds. I don't.
Well, unfortunately, we have a process.
You have another question?
Is this the right thing to do? That is my question.
That's the question we have to answer every minute of every day.
And is this going to cause the bill to pass or fail? Like, is this going to tip the balance one way or the other?
Well, ultimately, this is a question for the full body.
Right.
Yeah.
Because this is an amendment that will be presented on the floor.
Right.
All we are doing is providing a straw poll.
Yeah.
So it'll be up to the body to decide. All right, I'm going to have us move to just a straw poll vote with hands up. I think I'm going to say, please raise your hands to find the proposed amendment unfriendly, unfavorable. I think the technical term is unfriendly. So therefore, you would be as we raise our hands, voting to find it unfavorable, meaning there's a recommendation not to pass this amendment. All those who choose to vote that way, please raise your hands. Two on screen up. So I think that is a 10-1. Okay.
Can it be 0-1?
We don't have anybody absent.
Can I be absent?
Only if you're not in the room.
20 minutes ago.
Can we do it again and just leave the room?
I would say that- I would just remind us, all as legislators, we have one responsibility while we're here. Okay, the second amendment, I guess, given sort of the confusion around Rule 75 and the understanding that it applies, whether it's called out or not, but by calling it out, it adds confusion to it. I'm very hesitant on this one as well, given what we heard from Judge Zone.
Mr. Chair, I said I will be seeking, I'm going to talk to court right after that, this to figure out the right C, not include subsection C.
Okay.
In the amendment.
All right, so we're gonna just do a straw poll. It's not a binding thing, just so we have it on record.
Just wanted to clarify what.
Appreciate that. Okay, same vote, starting off, to find the amendment unfriendly, raise your hands. And we are 11-0 on that. Okay. I just,
Thank you, committee.
yeah, and thank you very much for coming in and taking the time. Thank you. Okay, I want to be respectful of West Council's time. So if it's okay with you, Representative McCann, going to let Council go first?
Yep.
Given your short time, if you could presenting the amendment first, then you hopefully will be done in plenty of time to go to your next obligation.
Is it on your website?
It is.
Which document are we?
It's under, it's on today's documents.
Oh, McCann proposed that. Got it.
Beth St. James, Office of the Legislative Council. Here is draft 1.1 of Rep. McCann's amendment to H 955. And just to summarize, it's not making any changes to the underlying law or the underlying work that you have done or House Ways and Means have done of adding 3 new sections. And the 3 new sections combined together would require all approved independent schools that are eligible to receive public tuition to follow education quality standards, period. So section 21B amends section 165, which is your education quality standards statute. And you'll just see throughout adding, right? It says that each Vermont public school, and then we're adding, and each approved independent school that is eligible to receive public tuition. That is quite a mouthful. I thought about putting in a definition for this section that said approved independent school means an approved independent school that is eligible to receive public tuition. But given the confusion around this topic, I thought that was dangerous.
I think that was a very good call.
So, we're just gonna have to read that sentence everywhere it appears. So that's what the language that is substituted through in there. There is no substantive amendment to what the education quality standards are. It's just adding anywhere there is a reference to a public school or a school board, adding also approved independent schools eligible to receive public tuition, or for school board governing body, as you can see here. That's what the first section does.
So I just want for the committee's benefit, that first ellipses right before number 2 would be our education quality standards statute.
And the ellipses are only there because this bill is already well over 100 pages. And so I'm not including language that hasn't been amended. So the next section amends is a little duplicative, but we're trying to make things as clear as possible so that there is no way for someone to misinterpret it, even though there always is. Amending section 828, which is the section that governs who a school district is allowed to pay tuition to. And so we've added in the criteria that an approved independent school needs to meet in order to be eligible for public tuition. We've added, so I've crossed out complies with minimum class size requirements because those are a part of education quality standards, and substituted that they meet all education quality standards. And then we've crossed out independent schools meeting education quality standards because that's under current law still a concept. This would moot that concept, right? You're requiring approved independent schools that are eligible to receive public tuition to follow education quality standards. So I just felt that was superfluous. And then the third section that you're adding is requiring that the State Board of Education update the Rule 2000 series, which is the Education Quality Standards Rules series, on or before March 31st, 2027, to require approved independent schools that are eligible to receive public tuition to meet education quality standards. And this date just tracks with all of the other rulemaking in the bill. That's the only reason I picked it.
Are there any questions? Yes?
Because I know there's always a question around therapeutic schools, because they're included as, on our list is just as an approved independent school. And are they singled out in any way, or are therapeutics, did I miss that somehow? I think I
So
missed.
section 828 lists all of the programs
Okay.
that are allowed to receive public tuition.
Yeah,
And the last one is therapeutic.
Oh, thank you.
Independent
yeah, I
schools.
somehow. Okay. That's it.
That changed, I think, last year.
Thank you.
Therapeutic schools.
Josh doesn't have them.
You just don't change.
Josh has his hand up. Josh, you're up. Go ahead.
So if all these schools need to meet EQS, would this make them all eligible to set their own tuition?
This amendment does nothing to change the current tuition statutes or the tuition statutes that are envisioned under the foundation formula through Act 73 or the changes you're making in H 955.
So I would say the answer is no.
I don't remember off the top of my head.
The answer is actually under the current way we do things, that an independent school approved to receive public tuition that meets EQS can set its own tuition.
Okay. Is there
Currently, under the foundation formula as perceived in 955, that would be no longer.
okay? So then, schools like Thetford Academy that follow EQS would no longer be able to set their tuition under the new foundation formula, correct?
Right. Once the foundation formula takes place, if the money follows the student, and that is the tuition.
Was there a fiscal note done on this amendment?
That's a question for the sponsor.
Rob.
My friends.
Thank you.
Of course, you know that I can't support this. And I would be,
I'm going to just interrupt you.
Yeah.
This is questions for legislative
Sorry.
council. We'll debate after that.
Good.
Okay, and the ellipses that I keep talking about on line 17 is significant if you go and you read rule.
I'll pull it up. So that's, well,
I would just say that it also then has to, there's a whole part below it, which is the Rule 2000 series. And I'm just going to bring up kind of one part of Rule 2000. There's lots of transition that would have to happen in order for an independent school currently to meet EQS. One of the big ones is it requires all administrators and all teachers to be licensed. I'm not trying to debate whether that's a good thing or a bad thing. All I'm saying is that that's a significant transition that would be that there's no provision in this amendment to how that transition would happen, how disruptive it might be, and that, which is only to say that that's just an important piece of this puzzle.
May I ask a question of the sponsor? Because
Why don't we, when we have the sponsor and the witness chair, unless it's a sort of a clarification of the language.
I don't think it will be clear. It's fine.
Any other questions for legislative council on this? Thanks very much.
Thank you.
All right, Representative McCann. Yes. Thank you for visiting the committee today.
Welcome to House Education. All right, for the record, Rep. Kate McCann from here in Montpelier, and I am a member of this committee. This morning, I bring to you an amendment to align public funding for education with existing law and expectations. The amendment would require publicly funded independent schools to meet the education quality standards adopted by the State Board of Ed. The introduction to the updated EQS reads, "The purpose of these rules is to ensure that all Vermont students are afforded educational opportunities that are substantially equal in quality and are equitable, anti-racist, culturally responsive, anti-discriminatory, and inclusive, thus enabling each student to achieve or exceed the performance standards approved by the State Board of Ed." Vermont's Constitution requires substantially equal educational opportunity as interpreted by the Supreme Court. The educational quality standards are the state's mechanism for defining and enforcing those expectations. If public dollars are funding a school, those expectations should apply. In other words, if a school receives taxpayer dollars, it should meet Vermont's education quality standards. EQS is the rule adopted by the State Board to define what a quality education must include. It is explicitly designed to ensure all students receive educational opportunities that are substantially equal in quality. And it translates a constitutional obligation into real enforceable requirements. It does not eliminate independent schools. It does not dictate mission, culture, or pedagogy beyond baseline standards. It simply requires that schools accepting public funds meet the same minimum expectations as public schools. And to close, I just want to thank you all for the opportunity to present the amendment.
Thank you very much. Representative Dobrovich online, you have the first question.
So to go to my original question, that Ledge Council couldn't answer was there a fiscal note?
No.
Okay, so that brings me some concern because in the interim, or if a foundation formula does not get triggered, this could become extremely expensive. And that does bring a concern. And I do wish that we did a fiscal note to determine what this looks like.
Other questions?
I do.
Oh, did you have a question?
Yeah, it goes back to the administrators needing to be licensed. Do we know, did you do any research? Do you know how many independent school administrators are or are not licensed? Do you know anything about?
I don't know.
Like,
I would just say that, you know, I'd say this continues to be an important issue and worthy of debate and testimony. I think if it were the will of this committee, after a fair amount of testimony and decision-making and all of that, to move in this direction, that there would be a understanding of what level of disruption or time would be needed in order to meet all of the licensing requirements, and frankly, all of the requirements of EQS, and sort of what level. And which is only to say, to be sort of silent with opinion, other than to say this is an important issue to be discussing. Accountability for how we spend our tax dollars, I think, is incredibly important. However, I think that it is not something that should be done within a floor amendment. So you will find me polling to find it unfavorable, really for that reason. Leanne? Oh, and then Rob, I'm sorry.
Would it be possible to, I don't know if this would be adding language or just like an understanding or some, I don't know how this works, but it takes like 2 years to get your license, right? If you're gonna go through peer review or if you already.
I've got to say that would be the kind of information that would be developed through testimony.
Okay, but like it is doable. It's not that hard to get your license if you deserve to get your license. And is there like a timeline that could be put on this so that we're like, yes, we're passing this, but it's not like you have to have it done in 2 years?
I guess I would say that we have to poll on the amendment before us. And that, the answers to those questions are things that you would need to have testimony on. Like what happens if 300 teachers all at once who aren't licensed want their licenses? I don't know if that.
I mean, that happens every year in our college system.
I just sent a little handout to Matt, and I hope he could put it up. So it's a Bees and fact sheet, and it talks about the 2200 rule series that independent schools have to follow, right? And in many ways, they're just as rigorous, if not more rigorous. And I think if you went to many of these independent schools, you'd probably find that most of those teachers were certified anyway. This is very interesting. It's very compelling. I would say take a look. Feel like, since I've been here, I'm battling this boogeyman that's out there that people think independent schools are, but they're not. They're serving Vermont kids really, really well. And I think that to Rep. Harple's point earlier, this kind of amendment on this bill that we've done so much work on could completely derail it on the floor. Completely. Now, I don't know if that's the plan, but that's kind of, I just have to ask myself. I mean, and while it sounds reasonable, I just think, take a look at the 2200 series. Look what independent schools already have to do. And you will find that in some ways, it's a much more rigorous process than our public schools. And if we talk about teachers getting certified, we have 800 people in the state right now at public schools that aren't certified. Like I said, in one famous email, we have bigger fish to fry.
Terminology, I think,
They're
license,
provisionally licensed, not
license,
certified.
license not certified.
Thank you.
Okay.
That's what I got.
Are you, when you get to that number, you're thinking about like provisional?
Yes. And emergency.
Right, I mean, that's on a path to license.
No, but I guess,
Well, I was,
legal
rather than
way
getting
to
into
be
a
teaching in
debate about
school.
this, I would just point out that licensing and all of that is something that would require a great deal of more knowledge and testimony. Any more questions for the presenter of the amendment, Representative Brown?
Are we in the moment where we can state some opinions? Okay. So I think I agree with a lot of what has been said here this morning, and I certainly really look forward to the day when a future House Education Committee takes a very deep dive into this issue of, the rules and regulations that apply to public schools versus independent schools. And I just have to say, one piece of the discussion that continues to really sort of irk me a little bit is I don't think we're here to debate how well our approved independent schools are serving students. We're here to debate basic fairness with public dollars. And I think it's really important to keep highlighting that.
Representative Harple.
Curious what education so we've talked about the licensure, which I actually disagree that they shouldn't have to be licensed and they can't get licensed, but at a reasonable timeline. But beyond that, EQS, what other EQSs are there that independent schools don't think that they can meet? And why shouldn't they have to meet them if they're an EQS?
The answer to that question, I would recommend looking at the Rule
Yeah.
2000 series
Right.
to see what EQS is. And I think that, it's meeting all of the curriculum sort of requirements under EQS. You have to look through it all. And for me, I'm not going to debate whether they can or can't do it. I'm just saying that that's probably a multi-layered, multi-year transition plan,
I guess
which this amendment doesn't provide for.
I guess my point is that it's a totally reasonable expectation, and like, if you're, as you're saying, they're meeting most of them anyway, then great. I kind of feel like, what's the problem? And when we come to licensing itself, I think it's like really important to remember that a teacher's license is not just going and getting a piece of paper signed. It's like studying special ed and law practices, and like, we want our teachers to be licensed.
Representative Brady.
Appreciate Representative Brown's point, and continue to find this very frustrating and think that the debate gets taken in a way that is not the intent. And I am concerned that continuing to not deal with it is also counter to the goals of Act 73, 955, all the sort of, I think, big shared goals most of us have, and that, having different rule systems, we're a small state, everything is, we're talking here about scale, about efficiency, about, we need to do things in a more consolidated, more efficient manner. And to have two entire different kind of rule systems, to have the state board devoting so much time, to have AOE staff, to have a whole division devoted to these matters and in such a small state, this is a really challenging, I guess it continues to surprise me at all the junctures we run into it of, small policy things we want to do, often just we all share, like for the best of kids, whether it's universal meals or it's some flexible pathways thing. And we run headlong into, well, we have to do it two different ways. We'll have to write the rules twice. The state board will have to go through two different processes. And I am frustrated that we continue to run into that sort of very inefficient way of doing things and good things for education for all kids in whichever school they're in. And so I appreciate the amendment. I understand, the feeling that it's too much to take on in an amendment. I also think we have taken over many years this on quite a bit. And so it's also, I think we're overdue to really figure it out and to make it a system that is in some way, I think we have, the academies, there are schools that are part of our system, how to do that in a way that ensures accountability, transparency for our public dollars and efficiency in terms of how we, create programs, rules, where we apply them, et cetera. And I guess I would also just note, since we're talking so much about teacher licensure, I believe that most of the teachers are in the pension system, the retirement system, the teachers in approved independent schools. So there are significant financial implications for our state. And that to me is another tie into why there should be common expectations. As the three of us know, there are significant financial implications to being licensed, staying licensed, et cetera. I'll stop there. I'm rambling.
Just remind us all that currently independent schools come in all shapes and sizes right now. Go ahead.
If I were to swing around there and sit in my seat, I would say that I believe that this amendment would actually strengthen H 955. And I think the stronger our bill is going over to the Senate would make me more comfortable about where we might get to as a compromise. And then the other thing that I would say, if I had swung over there, would be that I understand that this process would take a timeline, and I think that there are unknowns, but I think there's unknowns in 955 right now, some big ones. And so I don't think this is, any more than what we already have in there.
I might disagree a little bit and say that many of the unknowns in 955 are the subject of reports back and future decision making. This amendment kind of as a date certain.
I just want to share my thoughts on this. I actually have always believed that all schools that take public dollars should operate under the same EQS standards that we have. And I feel strongly about that. I want to echo Representative Brown's comment that this is not a reflection of the quality of independent schools that we have in the state. They're wonderful. We know that most all, if not all. And so I'm trying to keep this conversation separate from that. And we'll always try to continue to. But I have to say, I'm often baffled by the argument that not only are the 2200 rule series, which I'm familiar with, are at least as rigorous or more rigorous in that we often hear, and yet only one independent school has agreed that they wanted to follow EQS. And so I still remain, I'll say, use the word baffled again, why we don't see more independent schools adopting EQS as a standard. And I also feel an obligation to my constituents and taxpayers to make sure that tax dollars are used under the same umbrella in this case. So I'm strongly in favor of the concept of this, absolutely, and have been for many years, and my constituents know that. Two parallel systems is very challenging in the state. It's very challenging in my area. I am concerned about the timeline and the depth of debate that we should have over this. And I truly believe we should be having this conversation because I think it's a healthy one to have. And I haven't yet decided which way I'm going to vote on this, but I'm going to decide. But my biggest concern is literally timeline and the ability to have robust debate around this. And if we do not do this today, I hope that we will walk this path without fear. This should not be fear. This should not be division. This should be about our students in this state and our taxpayers in this state. And we should welcome that debate and that conversation.
Representative Purple.
I think one of the things Representative Brown also said that really resonates to me is that it is about fairness, and we're seeing the EQS change. And so one of the ones that has really been on my mind that is going to affect my communities is the minimum class sizes. And I absolutely cannot stomach the idea that we would take action against a small rural school for not meeting those minimum class sizes and then turn around and allow that money to go to a private school that also didn't meet those minimum class sizes. And that's, if we don't pass this, that's something that is a scenario that could actually unfold.
I just remind us that we have minimum class sizes apply
Yeah.
to both independent schools. and-
Right,
They have.
but the,
Depending on how the state board.
I mean, the possibility, the mechanism for closure changes in our rules, right? Like
well,
CG
yes.
Academy could still have a class size that was smaller and still, yeah.
Yes, but
Only thing is waiver.
the power that the state has is they would no longer be an approved independent school
Okay.
eligible to receive public tuition.
So you're just telling me that like a school like Riverside now is going to, in order to stay open, have to have class sizes that meet those minimum class sizes?
I would say that was what we passed, that there had to be
Okay.
the same and similar rules.
I guess this is all very.
Those rules all have both for the Rule 2000 series and the 2200 series, both are in rulemaking with the state board right now.
Yeah.
And both, I think, would, provide all of the sort of allowances that currently exist in terms of the process.
But I think that Rep. Purple makes a really important point, and the sort of complicated nature of all these things that we're setting in motion, and that, first of all, the class size piece is very much ongoing work right now at the state board. And again, there'd be two different, pathways here. There will be the EQS for public schools and Rule 2200 for private schools. And ultimately, in any, future state, right today, like, a school board could vote to close a public school. It will not ever have that authority, nor should it if it's a private school, but it will. But if that's where the public dollars are going, it does create it can create a very uneven sort of comparison and dynamic in small, particularly in rural Vermont. There is a different pathway of what could happen to different schools, given the dynamics of all of the things we have set in motion. And that's, I share that thought. I share that concern tremendously. And I think that's a very real thing in parts of our state.
That's a much more articulate.
A risk, and it's not a risk of not having.
I think you are all highlighting excellent discussion points that probably won't get solved at a floor amendment, which continues to be my concern. Not that any of these points are invalid or valid, but that it's something that would require some pretty strong depth of knowledge. Make a big decision on. All right, folks, as is our obligation as legislators, we will do a straw poll on this one as well. And we will vote in the same fashion that we have been voting in terms of finding the amendment unfavorable. So we'll go right to it unless anybody has any other questions. Those voting to find the amendment unfavorable for whatever reason, please raise your hands. 2, 4, 5, 6. People correct me if I voted wrong. 7. Up to there. If I count wrong. Did I count
I
wrong?
don't know, I saw a hand go, I don't know if she was fixing her hair and voting, so.
Again, please, everybody.
Okay.
Look up.
All
1,
favorable?
2, 3, 4, 5, 6.
6,
Did I count right?
7.
There's one not voting, it's not here and
Yeah.
here.
You have 7 hands up. That's what I came up with the first time, right?
I think so.
Yep. Okay, those who find the amendment favorable. I had 1, 2, and 3,
And 1.
and 1 absent. All right. Representative McCann, thank you for furthering the discussion and providing, I think, a robust topic for everybody. With that, we have performed our duties such as they are in our agenda. Please be back here at 11:15. I'm going to bow out to work on my floor report, so may not be back here for that, in which case the vice chair will run the show for the Adult Education Literacy Advocacy Day presentations. All right, we are adjourned.